Hey everybody, welcome to the channel. Hope you're having a great day. The time I'm filming this is 4:30 in the morning. Getting ready to jump on a plane and head back home from Florida. But I wanted to tell you something that happened yesterday. It came out like as I was trying to get a couple hours of sleep, so I figured I'd put it out this morning. That's a loss. We had a loss in the Second Amendment in a federal district court in Oregon related to ballot measure 114. If you don't remember, ballot measure 114, it was a magazine ban as well as a permit to purchase scheme that Oregon put into place, and it was challenged. And after a week-long trial yesterday, the judge said, you know what, let me just read it, because what he said is disgusting. Here it is on the screen. The case is Fritz v. Rosenbaum, and this is what the district judge said. Before this court are two core questions. One, can the state of Oregon limit the number of bullets to 10 that a law-abiding citizen can fire without reloading? And two, can the state of Oregon require firearm purchasers to obtain a permit which imposes various requirements, including a completed background check, safety training, and consideration of mental health status before purchasing a firearm? After a week-long bench trial, this court concludes that the answer to each of these questions is yes. Accordingly, Oregon ballot measure 114 is constitutional. Is it though? Has the judge not been hanging around? I mean, the Bruin decision? Maybe he hasn't heard of it. Check this out. Here's the next paragraph. As explained below, the plaintiffs have not shown that the Second Amendment protects large-capacity magazines defined as magazines capable of firing 11 or more rounds without reloading. And even if the Second Amendment were to protect large-capacity magazines, this court finds that the defendants and intervener defendant have established that Oregon's restrictions on the use and possession of large-capacity magazines are consistent with the nation's history and tradition of firearm regulation. Consequently, Oregon's large-capacity magazine restrictions are constitutional under the Second Amendment. This court also finds that the text of Oregon's permit-to-purchase framework is consistent with the type of regulations that the United States Supreme Court has deemed constitutional under the Second Amendment. Finally, this court finds that Oregon's large-capacity magazine restrictions are not an unconstitutional taking of property, are not unconstitutionally retroactive, and are not unconstitutionally vague. Accordingly, this court enters judgment for the defendants and intervener defendant on all of the plaintiffs' claims. So, this is going to be appealed. This judge must be smoking dope. He must be the one hanging around with Hunter and Joe at the White House and left something behind. This is, like, I'll link this decision down below. If you want to see into the leftist anti-gun judges thinking, read it. It's bad. Like, this judge is wrong on all kinds of levels, obviously, but he just violates case law, which has been set by New York State Rifle and Pistol Association versus Bruin. Terrible decision. This judge, horrible. There are no regulations from when the Second Amendment was ratified and adopted, or even the 14th Amendment that regulated how many rounds a person could have, or you needed to have a purchase permit for each firearm and prove that you're cool beans. It's starting to get loud here as people wake up and get here. I want to thank you all for your support. Man, and until we see each other again, be safe, stay vigilant, carry a gun to keep you, your friends, your family, your community safe. Subscribe to this channel, like the video, and share it so it gets out. I appreciate you all. See you on the next one.